to work on these. So first of all, I'd like to recognize Mark Burns, who is both the president of the PRDS board and the publisher, and works very hard on this committee, along with David Ziegel, Carolyn Miller, Carol Burnett, David Bergman, Ron Gable, Pete Aiello, Catherine Tomino, Louis Capin, Jan Jaramillo, and they represent the best and most active brokers, both for Silvar and Samcar, who are the beneficiaries of these forms. So moving on, I think everyone knows Dave. Dave has been actually Silvar counsel since 2010. But he is also shareholder at Rossi, Hammerslaw, Reichel, and Chuck. He's been in practice over 40 years as a litigator and arbitrator for residential and commercial real estate disputes on behalf of brokers, agents, buyers, sellers, landlords, and tenants. He teaches webinars and courses. He prefers to do them live, and writes on these subjects, including for Silvar. He is admitted to practice in all California courts, and he is, in my estimation, the preeminent California real estate attorney in the Bay Area. So Dave, take it away.
Thank you, Paul, and happily married to my wife, Michelle, my second wife, Vicki Nadorf, and my third wife, Molly Edgar, my assistant here at the office, none of whom I couldn't function without them. So, Paul, if you could pull up on the screen the BRBC, we are going to be taking a deeper look into this document than we did at a prior very short Silvar presentation. The first thing that I would like to draw your attention to is the title of the document. The title is, it is an exclusive buyer representation and broker compensation agreement. The significance of the word exclusive, which is repeated in the document, is that this does not provide for any sort of representation on a non-exclusive basis. I am going to be making some comments at some point about some of the primary differences between this form and the CAR form. One of those is that the default provision on the CAR, the current version of the CAR buyer representation agreement, is that it is non-exclusive. You have to check a specific box. Our committee felt that representation should be exclusive. We didn't want to get into issues that existed with respect to non-exclusive representation, including then who is entitled to compensation, who isn't or may not be the procuring cause. And quite frankly, most of us felt, how often do we have a non-exclusive or open type of listing contract? Therefore, let's just make it symmetrical on this side. Now, let's talk for a moment about it is a broker compensation agreement, meaning it is a contract to get paid. Who has the capacity to sign a contract for compensation? The answer is the broker, not an individual agent. And you will find that the location of the broker's signature is on the last page of this agreement, the very last page, page 5. But let me point out by saying, very bottom. Thanks, Paul. Very, very bottom. Brokers approves of this agreement by date, DRE license number. Please do not move forward with this contract without having a broker signature on it. Otherwise, agents, as we know, are not in their capacity as licensed sales associates, do not have the capacity to contract for compensation. Now, Paul, if we could go back to the opening paragraph. You will find that the very first blank is the name of the buyer. The term also includes any lessee, because this form can be used for a purchase, lease, option, or exchange. You will notice that in about 3 lines from the bottom on the right-hand side of that line. However, it also includes any entities that buyer has any financial interest in or control of. All of those collectively are granting to the broker, including any salesperson affiliated with the broker. And then we'll move on in a second here to the authority that's being given. First of all, there tends to be a lot of confusion, especially under the CAR version of this document, as to whose name needs to be filled in that first line for the broker. So we attempted to deal with this by saying, fill in the name of the broker, but then it says, including any salespersons affiliated with broker, and then you see collectively broker. The significance of that is it is a defined term. So whenever you see the term broker capitalized with a B in that regard throughout this document, or the term buyer, we have a defined term, and by including salespersons affiliated with the broker, who also obviously sign on page 5, as we saw, we eliminate, we hope, the confusion about who has the authority to enter into this contract. Now, the authority to do what? Well, it says the exclusive right, repeating again that this is an exclusive representation agreement, and authority to represent the buyer in assisting buyer in locating real property specified in paragraph 2, which we'll get onto in a sec. But in addition, do you see the words and or such other real property as may be acceptable to buyer? Again, we now have a defined term. Without the additional language and or such other real property as may be acceptable to buyer, the only definition we would have of property would be that which is identified in paragraph 2. And the committee felt that we might run into the following types of problems. Let's assume that somebody in paragraph 2 identifies property in a particular county, but then the buyer elects to buy a property in a different county. Same example for one city, and they move over into another city. So therefore, what we tried to do was come up with language that would provide, we hope, a catch-all. The catch-all being such other property as may be acceptable to the buyer, meaning if the buyer agrees to purchase through our representation another property that is not identified in paragraph 2, this will protect us during the term of this agreement in order that we can get paid. This is another distinguishing point from the current CAR version. The current CAR version means you're stuck with what you fill in paragraph 2. Now, the other part in this paragraph after the definition of property reads, and to negotiate terms and conditions acceptable to buyer, as I said, for the purchase, lease, option, or exchange. That, rather than repeat that phraseology throughout the document, we shortened it and we created defined terms: acquire, acquiring, or acquisition. So whenever we see those words, they include either a purchase, lease, option, or exchange. Now what you see of the property, now a defined term, and any personal property included in the transaction. In addition, buyer and broker are at times referred to as the parties, another defined term. Now, that identifies the authority to begin with to act on behalf of the buyer. And The next essential term is we have to have the term of this exclusive representation. So it commences on a particular date and terminates on a particular date. Once again, we need to have the parties in the introductory paragraph filled in. We need to have a term. And now moving on to paragraph 2, we need to have something filled in here, as most of you are aware of, in order to identify the property that is going to be the subject of this agreement. So you've got boxes: residential, commercial, vacant land, or other. And what we have is we created options for a county, for a city, or a specific address. Please note that what we did not include was a price point or a price range. Why? Because we did not want a situation where the buyer was going to be arguing, well, we went outside of a parameter identified in paragraph 2, therefore I don't owe you any money. In my career, I have handled 20, 25 disputes over buyer rep agreements. The first focus has always been on the essential terms, whether they're filled in with enough specificity that we have a contract signed by the broker because of compensation. But then the other focus has always been the paragraph 2, the type of property. And the focus here is, if what you fill in is too broad, then you might encounter an argument that the terms are unconscionable. In other words, they're unfair and they would not be enforced. Please remember that this document is created by us. There are rules that describe where ambiguities exist being construed, against the drafter of the document. We're going to be considered to be the drafter. We're going to be considered to be the person filling it in. So in terms of terms and in terms of location, what I would not want to see is, I would not want to see a term that was too extensive. What is too extensive? Well, conceivably beyond 6 months might be too long. The other thing in terms of location would be in any county in the entire state of California. I don't think you're going to have much success with that. The other thing to think about is balance what you fill in here with what duties that creates for you as a fiduciary. In other words, the broader and more expansive the description and the term, the longer your fiduciary obligations exist, obviously. And while you think it may enhance your ability to collect, that may not necessarily be the case. We have a new statute that's going into law next year that has to do with the length of a listing agreement and whether it can automatically renew. I think some of you may have already heard about that, and if you have, then one of the issues is that this would make that this is for listings. It would be unlawful for them to last longer than 24 months from the date the agreement was made, and unlawful for a renewal to last longer than 12 months from the date the renewal was made. I look at that as certainly guidelines that would apply probably to this agreement. But again, I think that going out beyond 6 months raises potential issues. Let's move on to agency relationships. Paul already mentioned that when this contract is printed out, it comes with the disclosure regarding agency relationships, the consent regarding multiple agency and dual agency. It comes with the BRBC. And among others, it comes with the needs and wants assessment form, which we're going to be talking about here in a minute. Here is what is critical. If you look at the existing CAR buyer rep agreement, one of the issues that it has raised right now is the fact that it requires a document called the BMI, the Buyer Material Issue Form, to be used in order to learn the needs and wants and issues and concerns of the buyer. What you will find is currently, and I stress currently, when you print out the CAR form, the BMI is not provided as part of that collective bundle of documents. So here we made it part of the bundle because we're going to look at this in a minute. This is the critical document for identifying what it is that the buyer is looking for, what it is that they want help on, what it is that they're bringing to the transaction, what concerns that they have. And the problem with the current CAR version is the most important form is not even packaged with what you print out when you print out their rep agreement. All right, now let's go down to paragraph 4. Paragraph 4 talks about broker's obligations. You can see here that it says that we agree to exercise reasonable effort and due diligence to perform the terms and conditions of this agreement. The next sentence reads that the parties understand, acknowledge, and agree that this agreement is not intended to change, nor shall it be construed as changing any common law, ethical, or statutory duties that the broker owes to the buyer. What are those duties? Well, many of them I'm sure you're aware of, but common law includes common law fiduciary duties to the buyer. Now, one of the historical issues that has always existed with the CAR rep agreements, whether the current one or the ones that were broken out into 3 separate forms, was for years, CAR was trying to limit and restrict what duties and obligations existed when you represented a buyer. What were they trying to do? They were trying to pigeonhole themselves into the civil code sections that essentially limit your obligations to conducting a visual inspection of the reasonably accessible areas of the property. The problem with that approach is that it was in conflict with common law fiduciary duties and the obligation to learn and make an inquiry on the part of your client. Obviously, when you are representing a buyer, under an exclusive rep agreement, you are going to be in a fiduciary relationship with that individual. Under Casey Jury Instruction 4107, that means, among other things, putting yourselves in the client's shoes and asking the kind of questions you would want to know if you were the client, so that the client can make a full and informed decision. So, philosophically, what this contract does not do is attempt to limit or restrict what your duties and obligations are, because as a fiduciary, you would have to explain that the contract was doing so. If you failed to do so, that in and of itself would be a breach of fiduciary duty. Let me give you an example. If you were to come into my office and I were to have you sign a fee agreement, and that fee agreement said, by the way, my duties and obligations are going to be limited, even though every other lawyer who you might work with would have a broader set of duties, or the time frame in which you could bring a claim against me is shorter than what the law otherwise allows. anything of that nature would create a problem for me if I didn't fully explain those limitations and restrictions to a client. What if my fee agreement said, hypothetically, by the way, if I make a mistake, my damages are limited to a certain amount of dollars. Well, in some instances, you can get away with that where you have an arm's length relationship, people represented on both sides, not where you have a fiduciary relationship. So we just felt that stressing this is, we're not changing any of this. We're going to use reasonable efforts and due diligence, subject to the other laws, ethics, and statutory duties that exist. Now, paragraph 5, buyer represents and warrants that buyer has not entered into any type of rep agreement with any other broker, including a sales associate, and agrees not to do so during the term of this agreement. In the event that buyer breaches this rep and warranty, broker shall be entitled to the compensation specified in paragraph 9 below. All right, this addresses the issue of what happens when the buyer either has already entered into an agreement or enters into another rep agreement during the term thereof. We, as a committee, felt we want them to not do that, of course, and the consequence for doing so is what we spelled out here. We get paid as specified in paragraph 9, which we'll get to in shortly. How does this differ from the car agreement? The car agreement has a paragraph about this, but it basically says if there's a prior rep agreement, the second broker is out of luck. Now, if that prior rep agreement arguably is non-exclusive, and the rep agreement that you are working under that form is also non-exclusive, which is, remember, the default position, maybe you get into a procuring cause battle. But the way that Carr has drafted it now is broker number 2 is SOL, out of luck. We didn't think that was appropriate. We think the onus should be on the buyer. They're making a rep and warranty to us, and we discussed and said we're going to get paid in the event that that rep and warranty is breached. Paragraph 6. During the term, buyer agrees 1, to work exclusively with broker and not any other broker, salespersons, or sellers/owners with respect to viewing, either in person or electronically, the property, acquiring the property, that is acquiring in some form the property that's been identified, and to refer to broker all communications in any form from any broker, salesperson, owners, or any source, etc. Now, again, this is not intended to change common law, ethical, or statutory duties. But on the other hand, we wanted to underscore you are working exclusively with us with regard to all of these things, and to refer to the broker all communications. Now, do you see where it says acquiring the property? Again, we definitely want something filled in paragraph 2. Do not rely exclusively on the catch-all language in the introductory paragraph, which is just designed to see if they actually acquire another property during the term that is acceptable to them, that you as the broker assisted them on, because otherwise that's the only time that language will help you. So you definitely need to fill some identification of the property into paragraph 2. All right, Paul, could you please scroll to the top of page 2? Okay, this paragraph 6A, 1, 2, and 3, and 6B define a series of responsibilities of the buyer. So let's try to work through this. The buyer shall provide the broker with all of the following information and documents detailed below in a timely manner. Buyer ensures and represents that everything buyer provides to broker is accurate and complete. Now, we obviously want certain docs and information. We want it in a timely manner, as it says, and there's a rep that it's accurate and complete, because we're going to be relying on it. And when we get down to the needs and wants assessment form, one of the reasons that document becomes important is because it can help us identify our value, our worth to a buyer by the information that they provide. This paragraph 6A then goes on to say that the buyer is to provide broker with all of the required information, one, not only at the commencement of this agreement, two, but also as soon as the buyer identifies a property, and three, at any time that the buyer receives and reviews any advisories, disclosures, reports, or other documents or information provided not only by broker, but by the seller/owners or any other source. Here is the key to this. The key is knowledge evolves, needs and wants evolve, issues and concerns evolve. We heard in the committee the issue about, well, the buyer comes in and says they want a 3-bedroom, 2-bath house, and they end up buying a condo. How the hell did we get from, buying a 3-2 to a condo? Totally contrary to what they originally wanted. So if things are changing, we want them to update that. So again, 3 different times. The commencement of this agreement, as soon as the buyer identifies a property, meaning one they want to make an offer on, and after looking at the advisories, disclosures, reports. Please remember that one of the bundled documents is the market conditions advisory. Another one of the bundled documents is the San Mateo, Santa Clara 2-county advisory, all of which identify issues and concerns that a buyer should be focused on. And we want them to collectively look at whatever information they have received and update us when they have new needs, wants, issues, or concerns. All right. 6A1 spells out those parameters. Accurate and complete information in writing. We want it in writing about buyers' A, needs and wants, B, buyers' issues, and C, concerns with respect to acquiring the property, including but not limited to that information that will materially affect buyers' decisions regarding what to buy and how much to pay. Now, we have indicated that this information can be provided to the broker in any type of document of buyer's choosing, provided that it is in writing, or buyer may elect to fully complete a PRDS buyer needs and wants assessment that is attached to this agreement. Unlike the current version of the car contract, if you and your buyer want to communicate through text and through emails, and that is the mode of communication of the buyer's choosing, you may do so, or you may elect to complete the needs and wants assessment. When we get to that document, we're going to see that that document, page 3 of that document, will be updated by the buyer with each property that they identify. So if they start off with one property, but they discover and find another property they like, then they will have the opportunity and will be required to update it and to tell us whether any of their other needs and wants have changed. Now, interestingly enough, the current version of the car buyer rep agreement requires that the BMI be used, number one, does not provide for, quote, any other comparable or comparable form or any other collective group of writings. I believe the committee felt we're already talking to clients about their needs and wants. We're talking to them on the phone, we're talking to them in person. We are sometimes documenting those in writing through text and emails. The key here is if you do have an oral discussion that modifies what is in writing and you're working through texts and emails, take the time to document it and confirm this either has changed or altered their needs and wants or their concerns. All right, paragraph 6A2. Regardless of the means chosen, buyer shall provide broker with accurate, complete, and relevant personal and financial information and documents to aid in buyer's ability to obtain financing. In other words, when we start working with a buyer, we need to know what type of property they're interested in, but we also need to know what financial ability they have to pay or afford a property, because we don't want to be working and showing people property that they don't have the financial ability to buy. However, this paragraph spells out, buyer understands, acknowledges, and agrees that unless broker agrees in writing, broker shall not be responsible for obtaining or arranging financing. Buyer shall rely exclusively on their mortgage broker or lender with respect to all financing issues and concerns. Now, does that mean that if we step over the line with our conduct, with our actions, and start advising them on these issues, that we may not have a problem? Of course it does. We can put whatever you want in writing here to try to protect you. But when you cross the line, then you potentially have, some responsibility. Do we also recognize that a broker at least needs to be looking at what was provided by the client with regard to a pre-qual or pre-approval letter or bank statements? Yes, I think you do. Now, there's a good reason why these things are, these seminars aren't recorded, because we want to be able to speak to each other candidly about things and not have to fear that they're going to get used against not only you, but also me as a lawyer or as an expert witness if we cross the line. But financing, leave it to the mortgage broker or lender. However, take a look at what's provided. For example, if we have a buyer who is an entity, but we don't get any financial statements from that entity, we need to say to the client, hey, where are the financial statements for the entity? If somebody doesn't have the authority to act and they need the authority, then we need to get that type of documentation. If somebody is going to provide you with a pre-approval or pre-qual letter that's based upon a certain type of financing, and they end up writing something that is a different type of financing, I think these are things that we ought to address with the client privately before moving forward. All right, 6A3. All written information detailed in A1 and 2 is collectively referred to as buyer's info. We again state the info may be provided in person, by mail, or electronically. It needs to be, however, in writing. Buyer shall be responsible for updating the information in a timely manner as set forth herein, meaning those 3 occasions identified in 6A. Now, in the event that buyer fails to timely provide the buyer's information and or provides false or inaccurate information, broker shall have the sole and exclusive option to cancel or terminate this agreement and or pursue broker's legal remedies. So we have built in the consequence for a buyer failing to meet these obligations. Let's talk about why we chose pursue broker's legal remedies, because we didn't want to try to limit or restrict. We wanted to leave it as open-ended as we possibly could. And that's why we chose that particular information or verbiage, excuse me. Now, B says you're going to be receiving, the buyer's going to be receiving all sorts of documents collectively defined as documents. which are prepared by various sources. Another obligation is for the buyer to carefully read all of the documents in a timely fashion so as to determine whether the property meets buyer's needs and wants, financial and to determine whether it raises any issues or concerns, to better understand the contractual, financial, investigative rights and duties, etc. Okay, broker, and to update the broker as required above. Buyer should follow recommendations for further inspections and or investigations that are made by any source, including what's identified there, including whether provided orally and or in inspection reports. Now, why is this language in here? This is designed to protect us. This is designed to protect your responsibility to the buyer and try, and I stress try, to shift the burden onto a buyer. However, under the Casey jury instruction that I referred to a moment ago, the common law fiduciary duty that I described to you is measured in part by the knowledge, training, skill, and experience of your client, the questions that your client asks, the type of property and the terms and conditions of any sale related to that property, and some other similar factors. What this basically means is, as a committee, we can come up with language like this that we can put up in neon lights in front of a judge or a jury or an arbitrator and say, look, the buyer was obligated to do this, this, and this. They didn't do it. However, if in fact your buyer is not very sophisticated or has sent you a lot of emails, obviously saying, I don't understand this, I don't understand that, I need help. These are the types of things that we have to be responsive to. On the other hand, if you were representing me in a transaction, you might be able to get away with relying on my knowledge, training, skill, and experience to be able to understand what I needed to do as a buyer in order to protect my rights as a buyer and evaluate something. There is no hard and fast rule on this. Some people may be sophisticated on financial issues, unsophisticated on the condition of the property issues. But remember, when we get to the needs and wants assessment, we are trying now with the world as it may be moving on to, and what I mean by that is buyer rep agreements, traditional form of compensation no longer being applicable. If we're moving into that world, we need to define our value and worth to a buyer. We need to identify what that buyer wants, their needs, and tell them this is how we can help you in reaching those needs and wants. Now, C says fully investigate all of the needs, wants, issues, and concerns, as well as everything covered in these documents. By the way, going back, just Paul, you don't need to scroll the screen back. The needs and wants assessment form. Vicki felt that it was critical to have a written form that was used repeatedly to potentially eliminate any fair housing claims. Historically, fair housing claims have arisen because somebody has not been treated in the same way. The problem with having oral communications, even if you try to document them, is we don't have a standardized set of questions that necessarily are being asked. Maybe you do, but many people don't. So one advantage Vicki felt of the needs and wants assessment was to potentially eliminate fair housing types of claims. All right, if we go, Paul, scroll down just a little bit. Buyers shall retain qualified appropriate professionals to assist them, pay for reports, conduct all negotiations and contractual obligations in good faith. And then we have a disclaimer here, a disclosure about confidentiality. What we have in this document shouldn't surprise you. It's in many other documents, but if this is going to be our exclusive rep and compensation agreement, we felt that we needed to include as much of this in this particular document so that when you present it to your client, review it with them and have them sign it along with the other documents, they've got a complete picture of what you're going to be doing, what they're going to be doing, in what time frame, and what compensation, etc. All right, Paul, if we could move on here. All right, let's get to express assumption of the risk. What the hell is that doing? Well, we had an interesting discussion about having what is known as an express indemnity clause. Express means it's in writing, it's in a contract. Indemnity means the passing of responsibility from one party to another. You are all familiar with the express indemnity clause that is currently in our listing contract. That express indemnity clause is, excuse me, let me just see if I can quickly put my hand on it. Oh. What it says in short is that if a seller fails to make a full and complete and accurate disclosure in responding to questions about the condition of the property, and there is a lawsuit that arises out of that, the seller is obligated to defend and indemnify the broker. You will find that in paragraph 10 of our agreement. And it is triggered by, among other things, any incorrect or incomplete information supplied by the seller or seller's failure to provide documentation required by law or this agreement, etc. Now, the issue with this clause, by the way, CAR has a similar clause in their listing contract. They also have a similar clause in their current buyer rep agreement. Here is what the concerns are that prompted the committee to go away from express indemnity in favor of assumption of the risk. And by the way, whether assumption of the risk is going to be any more enforceable than an express indemnity clause remains to be seen. However, this is what drove this decision. There is law in California that says if you have an express indemnity clause, such as the one in the listing, such as the one that is currently in CAR's buyer rep agreement, your rights against the broker rise and fall on that one clause. In other words, you give up other legal recoveries, other legal theories against, in this case, it would have been the buyer. Now, the enforceability of an indemnity clause, such as in the listing contract or what's currently in the CAR contract, would require that a decision maker find us to be absolutely without fault of any kind. If we were found to be even 1% at fault, the enforceability of that express indemnity clause would be in doubt. And therefore, if the law says, well, your rights rise or fall on the express indemnity clause, then that's not a situation that I thought was a reasonable one in this particular agreement. In addition, if you look at paragraph 10 of our listing contract, what is excluded from the indemnity obligation is attorney's fees and legal costs. So all of you are familiar, I'm sure, with the following. There has not been an industry contract at any level, whether it's PRDS, CAR, that has contained an attorney's fees clause whereby a broker has direct liability for attorney's fees. for quite some time. We eliminated attorney's fees from our listing contract a number of years ago. Carr finally got on the bandwagon also, several, 3, 4, 5 years ago. However, this is where I have a concern about the current Carr buyer rep agreement. The indemnity clause includes the ability to recover attorney's fees and costs. So my concern is if that clause is not enforceable or the broker is found to be at fault, they just took on an extra liability for attorney's fees and costs, which wouldn't otherwise exist. So there is a danger there, even though the Carr current version of their buyer rep agreement in a different paragraph says each party will bear their own fees and costs, which is now their universal position, as I said, in their listings, their purchase contract, and even in their buyer rep. But the concern is they've let in through the back door, through the indemnity clause, what they've otherwise tried to exclude. It will be a gotcha for some broker, ultimately, especially when you think about the fact that currently, and the reason I'm stressing currently is I believe Carr will revise their agreement at some point. How quickly that happens, I can't say, because they typically only make modifications twice a year. But currently, the required form to use, as I said, to learn the buyer's concerns and needs and wants and whatever's going on in their brain, is the BMI. Now, Paul, I don't know how we can do this. There are 242 people supposedly listening to me right now. We're going to make a lunch bet like I normally make. If anybody can tell me and prove to me that they used a BMI in a transaction in the last 5 years, I will take you to lunch at your favorite restaurant. On the other hand, if you can't produce a BMI in your file that was used by you, not by somebody else, in the last 5 years, you're going to take me to lunch. Why? Because the BMI has been in Carr's library since 2005. The number of times you will find that used by anybody in a transaction is slim and none. The next thing you will find about that form is it provides no guidance or direction to the user about when it needs to be filled out and when it needs to be updated. So remember what we went through earlier, the needs and wants of the buyer, the issues and concerns. There are 3 times when they need to update that, because those are the times when their criteria may change. The BMI simply talks about, it's got 4 or 5 blank lines for the buyer to fill in without any guidance or direction. No specific questions. It leaves the entire onus on the buyer. Even if the form has been used historically, more often than not, there's nothing filled in. It's just signed and dated. So I'm posing this to you because currently, if that is the required form under the Carr rep agreement, and you don't provide it to the buyer, if you don't provide it to the buyer, then the starting point for determining the buyer's needs and wants, their issues and concerns, and your ability to enforce the indemnity agreement in that contract is already in jeopardy, because you haven't even given them the one resource which is required under that form. Now, you could use the needs and wants assessment that we're going to talk about with any contract. It's not tied to the PRDS one, but currently the language says shall use the BMI. That's the problem. All right, what is an express assumption of the risk? Well, in California, when you participate in an activity that has defined risks, then if you have, typically these are in personal injury type things or activity type efforts like skiing, road racing, things that are dangerous, inherently dangerous. You sign something assuming the risk. So we as a committee discussed and voted on this particular attempt to try to pass on the responsibility and risk to the buyer without including any exposure, inadvertent exposure to attorney's fees, and without the potential impact that if it's unenforceable, we still have common law indemnity rights, common law equitable indemnity rights, which is a legal theory, to pursue against the buyer. All right, so what this says is, if the buyer fails to perform any or all of the buyer's obligations, they're doing so against the advice and recommendation of broker. Where have we seen this language before? Every single advisory that we as an industry create has language of this nature and is assuming any and all risks that may occur arising out of, related to, associated with, etc., the buyer's failure to perform any and all of their obligations. This language should not be a surprise to you. This language is, as we mentioned, it's in most of our advisories. And what we are trying to do is say, buyer, if you don't follow what we've told you to do in these advisories, it's on you. Same thing here. We then go on to identify what these risks might be. Notice the language, include, but is not limited to, meaning we can go outside the parameters here. Unable to properly evaluate the condition, code compliance, permit status, use, development, and or value of the property, or to make other informed decisions about the acquisition of the property because the buyer may have incomplete, inaccurate, or insufficient information or documents. Buyer's assumption of the risk shall release broker from any action or claims by buyer in any forum, and any and all liability to buyer arising out of the acquisition, including the condition, unless the broker was grossly negligent or intentionally harmed the buyer. Those are the typical qualifiers for an assumption of the risk clause. All right. Any forum includes at an administrative level is what we were trying to broaden it out to do without specifying it. We didn't want to sit there and put a neon light on an administrative action. Now, buyers advised to consult with a qualified California real estate attorney to better understand the legal significance of this paragraph before signing and any other legal issues or concerns. Why did we not have initials? Because where you require initials and you don't get the initials by oversight, you then don't get the benefit. For example, as I told you, the car contract currently is default is non-exclusive. In order to make it exclusive, you have to check one box. In addition, you will see that under the safety clause, which we'll talk about here in a minute, under the car rep agreement, you have to fill in a blank space. What you'll see here in paragraph 9 momentarily is that we had a fixed period of time, 90 days. Why? We don't want blanks. We don't want people to have to fill in a date and potentially miss it. All right. Limitations on broker's responsibility. Language should not be a surprise to you. Again, not an expert on law, insurance, tax, financing, and other professional fields described in advisories relating to the condition of the property. Go talk to qualified people. Once again, what is the only concern? We can't overstep the grounds here. Okay, if you don't know something, I don't know something. Here's a resource to go get it. B, does not decide what price buyer should pay or what the seller should accept. Cannot guarantee that buyer will be able to acquire any property. Then we've got our typical issue here about square footage and things of that nature. Again, think about the language limiting our responsibilities that are in most advisories. These are now incorporated into this contract. Fair housing, we certainly should be sensitive to. We've talked about it briefly, why we think the use of the, the needs and wants assessment being a unified and consistent document is a good way to avoid potential issues. All right, compensation. Paragraph 9, they're negotiable. My God, that's the biggest issue on the horizon right now. Now, interestingly enough, if you look at paragraph 9, most California transactions, seller pays licensees regardless of agency. That's the current. However, in certain circumstances, buyer may agree to pay buyer's broker for services rendered. Now, at the time that we prepared this form, we gave the option of a dollar amount or a percentage. What may be arising is we may have hybrids. So at some point, you may want to say, I want to work on an hourly basis for a certain amount. I want to be reimbursed for these expenses. If you want to go into that now, then I would create an addendum. If you like any contract, this contract, paragraph 10, has additional terms. You would type in C addendum, Ray compensation, and fill out an addendum, date it, and sign it. As of right now, however, we've got dollar amounts or percentages, as does the current car versions of their form. Now, we broke out the compensation for the sale of the property. And notice it says a brokerage fee at close of escrow on the property as defined in the introductory paragraph and or paragraph 2 above. Why? Again, to tag in if the buyer buys something that we represented them on and it's not in paragraph 2, we are hopefully going to be able to get paid. Now, we broke it out. B relates to an option. C relates to a lease. And then D provides that we can request that the seller or owner pay some or all of the compensation in paragraph 9 as part of the offer to acquire. Seller or owner is not obligated to agree so. However, if you see in the bold print there, if the broker receives compensation from the seller owner or any other broker, then said sum shall be credited against the amount due to broker from buyer. Okay. In the event that broker receives a sum in excess of the amount specified, broker is authorized to keep that sum. If you want to sit there and divide it up with your client in some way, then paragraph 10, see addendum. Broker shall promptly disclose to buyer the amount and source of any compensation paid in connection with any transaction, divide compensation, etc. Now, before we get to the safety clause, let's talk for a minute about when is this discussion going to take place and how. Currently, our purchase contract does not have any language whereby that discussion can be triggered as part of the contract. Our committee is going to have a discussion about whether language should be added to the contract or not, or whether if you want to make that request, you would simply fill out an addendum with your request. Now, the philosophies here that are competing is currently the car RPA has a box that needs to be checked in the event that you have a buyer rep agreement signed and you're going to be asking for the seller to pay all or some of that compensation. It forces that discussion into the negotiation with the seller over the purchase of the property on other terms and conditions. There are some members of our committee who believe that doing so actually works to your disadvantage in terms of how much you might be able to negotiate. The other competing philosophy is have that discussion with the seller, with the listing broker, before the offer is written by using a cooperating broker or some form of compensation agreement form, and get that out of the way before you get into the balance of the discussions. Now, this contract in paragraph D has what you and I know as a safety clause. It says the above compensation shall be due to broker if buyer or any person acting for buyer or on buyer's behalf acquires, again, defined term, any interest in the property during the term of this agreement through the services of broker or otherwise. Said compensation shall also be due if within 90 days. So we filled in the date for you here. After the termination or cancellation of this agreement or any extension thereof, and you see the three triggers for getting paid. Please pay close attention to the very last line and a half. Provided that buyer has received written notice of the addresses of such property before termination or cancellation of this agreement. So in order to get protected under this safety clause, you have to provide written notice of the addresses of any property before termination or cancellation of this agreement. Now, when I was reviewing this contract again to get ready for this discussion, guess what dawned on me? How do you provide written notice before a cancellation if you don't know the cancellation is coming? So I think what I'm going to be taking to the committee very quickly is that this should be within 10 calendar days of termination or cancellation. The other thing that I'm going to point out to you is this works for termination, but there's a risk here that it may not apply if there's a cancellation, a unilateral cancellation. By the way, there is no mention of cancellation in this contract. Why? Why do we want to bring that to the buyer's attention? Number one. But number two, the law allows any party to cancel a contract at any time, provided that they are prepared to accept the consequences of doing so. So in this particular instance, if somebody's going to cancel, once we get this language cleared up regarding when in relationship to the cancellation you need to do it, then this is how you protect yourself, just as you do under a listing contract. Now, under the car buyer rep agreement, the notice has to be given depending upon whether you have exclusive or non-exclusive representation. So in other words, if it's non-exclusive representation, the default provision under the car rep is you've got to give the notice immediately upon within 5 days of cancellation. If it's exclusive representation, you get a grace period. You can change that by checking a box and altering it. However, as I said before, those are the provisions that apply to cancellation versus termination. They have an added safety clause in addition to that, but it requires that you put in a specific time frame, and if you miss it, you don't get that protection. Now, last paragraph of paragraph 9 says, in the event that buyer enters into any subsequent representation agreement with any other broker, buyer is advised to exclude from said agreement any of the properties listed by broker in compliance with this notice provision. And then we have the irrevocable assignment language that's typically there. Paragraph 10, additional terms, is for just that. I've given you a couple of ideas. Attorney's fees and cost. Do you see that it says in any action or claim arising out of this agreement, including for the payment of commission, parties say each side shall bear their own attorney's fees and costs. Why? Because this is the same problem that existed in both listing agreements. We were the first ones to eliminate it. Carr then followed suit. If you have a claim for compensation, but you have an agreement that spells out other duties and responsibilities you as a broker are to be providing, the risk is you will then bring those into that claim, and if they are unsuccessful, you may end up paying attorney's fees. So this is designed to cut off that liability, and I cannot tell you how powerful this really is, because one of my responsibilities when I'm talking to a client is I have to explain to them, look, you can go after the broker if you want, but you're not going to be able to recover your attorney's fees. So you got to gauge how much I'm going to spend versus what I'm going to stick in my pocket at the end. So that's why that's not there. Authority to act is self-explanatory. One of the things CAR's contract didn't have is the issue about if it's an entity promptly obtaining and providing all legally required documentation that may be necessary to facilitate this. Then you say here, in the event that the buyer fails to provide this information in a timely fashion, we have the sole and exclusive option to cancel or terminate. So we do, and pursue legal remedies. Now, another thing, paragraph 13, the current CAR document doesn't address this. How am I going to be communicating? What forms of communication are going to be acceptable? This paragraph says all means of communication that the parties include in the blank lines below the parties' signatures on page 5. You will see that those blank lines, as they do in many purchase agreements, talk about telephone numbers, email addresses, text numbers, current addresses. Current CAR rep agreement doesn't incorporate any of that into the agreement. This also has a authorization by default to accept documents sent by means of a link embedded in an email. That's not in the CAR rep agreement. Last thing, it's the entire agreement of the parties. Then we have some language here. Once again, go consult with a qualified California real estate attorney before signing this agreement. And then it says, again, they have read and approved each and all of the provisions and have had the opportunity to consult with a qualified California real estate attorney. Now, we then have signatures, date, again, get the broker's signature at the bottom of page 5. Couple of quick comments before we move on to needs and wants. Many times, it's not only what's in the document that's significant, but what is not in the document. So what is not in this buyer rep agreement? What is not in there is a mediation and arbitration clause. Why? Because currently, under both contracts, the RPA and the PRDS contract, brokers have the right to opt in to the mediation or arbitration. Obviously, most companies and or insurance companies will never agree to opt into a binding arbitration, but you have the option of opting into a mediation. Well, if we included a mediation clause in this contract, we would have been obligating you to participate in a mediation, because one of the things you have to think about is this. This is a rep agreement as well as a compensation agreement. Let's assume that the buyer has a problem with the seller, files a lawsuit against the seller then brings a claim against you as the buyer's agent, saying you didn't do your job, didn't do your fiduciary duty. If there's a mediation clause in here, in all likelihood, you're going to get dragged into that. Same thing with an arbitration clause. That's why you will not find those particular items here. All right, now, let's move on to the needs and wants assessment. First of all, you don't have to use this. Second of all, if you like it, you can use it with any other contract, as long as the language will allow for a comparable form to be used. What the genesis of this is, I have here in my hand, now you can see it, the NAR Accredited Buyers Representative course material. Some of you may in fact be a accredited buyer's rep. CAR does not have a program currently. They rely on this program. All of the courses that they are now providing on their buyer rep agreement do not qualify any more than this course does. But I'm going to read you from page 43 of the NAR material. There are two key aspects that you need to learn about the buyer during the counseling session. This is the initial counseling session. What the buyer needs and how much the buyer can afford. Because without those two things, if you look at this course material, NAR's position is you can't, number one, demonstrate your value to the client, identify what their expectations are going to be, and you can't figure out whether they're qualified to buy the kind of property that they're trying to buy. Now, the other thing you will find is that at page 45 through 48 of the NAR material, there is a new buyer consultation worksheet. And it's got all sorts of information about phone numbers, emails, first-time buyer, repeat buyer, second home. Are you working with another realtor, current living situation, financing? And then it goes on to buyer's needs and wants. And there's several pages devoted to that. I'm going to tell you with a great deal of pride, you can tell me if I'm full of it, that I believe that this document that the committee came up with is better than what's in the NAR course material. Why? If you look at what we're asking these people, the buyer to tell us is, Paul, just for a minute, we've got general preferences, needs, wants, and concerns. Okay? Now, preferences is a defined term. So wherever that word is, it means needs, wants, and concerns as well as preferences. We felt it was important enough to spell this out, even though it's the term preference is defined. So the first section of this form talks about personal and financial information. The second section of this talks about property preferences and concerns. And the third talks about expertise and past experience. Why do we think that this information is important? So that we can better demonstrate what our value is going to be by knowing what their needs, wants, and concerns are, how we can help them address that. And then in addition, as we say here, to enable your broker to help you in searching for and acquiring real property, tell us this information, okay? Then it says, the updated assessment form seeks information about a specific property that you have identified that you wish to acquire. That is the third page. Please complete all these sections to the best of your ability. It's not the agent's responsibility. Now, caution. Depending upon your financial ability, current housing inventory, and other market conditions, you may not be able to find property that meets all of your preferences. Many buyers ultimately make compromises when choosing which property to acquire. It is your responsibility to determine whether it meets your preferences and how much you're willing to spend. Why is this in here? Because some of our committee members said, wait a minute, remember the example I gave you? I start off with a 3-2 and I end up buying a condo. They were concerned, how do we make sure that we don't get stuck in some way? That's what this caution is designed to address. The next thing is, the next paragraph is very important. The information in this assessment constitutes confidential information, including that which is defined in that civil code section. That civil code section defines what information can be transmitted in a dual agency and what can't be. So price, motivations, and other factors. We have characterized everything in here as confidential, and it says, regardless of agency relationships, this assessment will not be disclosed by agent to anyone, including any potential seller, unless buyer authorized agent to disclose any and all information contained in this assessment to the person or persons specified by the buyer. So if a buyer has concerns about, well, wait a minute, I don't want to tell anybody this. It's not going anywhere. It's between you and the buyer. That's what this is intended to do. Now, what you will find in section A, we've obviously got, names, contact, preferred price range, but then we start getting down into some issues. And these are issues that our committee have all experienced. So the first one there, amount and source of initial and down payments. We've had a lot of problems over the years, as I'm sure some of you have, with gift money, sale of stock. We want to know that now so that we can address it. Pre-approved for a loan. What's the loan contact, the lender's contact information? Promptly provide the agent with a copy of any pre-approval letter. Type of financing. Here's another question. Financial concerns or pressures. In other words, what limitations do you have? What are you facing? Are you about to lose your job or not? Something like that. Why are you looking to buy at this time? that is something that's in the NAR material. I thought it was a good question. Do you need to sell any property before you're able to buy? Do you have any timing constraints, e.g. a 1031 exchange? Do you intend to reside in? On and on. This is, are you buying the property for someone else? Are you acting on behalf of a trust or an entity? These are all issues that have come up that have prompted claims. So we're trying to eliminate them. But what's more important is, how are you going to turn this into a positive with your buyer? The first thing is, and this is not my original thought, if your buyer is unsophisticated and doesn't understand or have a good overview of the entire buying process, you might start off by explaining, well, listing agents work with sellers. They have them sign exclusive listing agreements. Those listing agreements provide for the following activities to be undertaken by that listing agent exclusively for the seller. Now, there will be a discussion at some point about offers of compensation, but generally speaking, that listing agent is going to describe the process, what they're going to do, how it may work. If you're working with a buyer who doesn't have that experience, you might start by making that explanation. And then you would move into, this particular form is going to help me assist you in locating property. This is going to help define what it is that you may be interested in, what your motivations, your concerns, and your needs are, so that I can better represent you. By talking about that and gaining the confidence of the client, you are going to demonstrate your value, in my opinion. I think you've heard me say, when I've got clients that come into my office, I ask them to tell me in a timeline what's going on, but then I also ask them to tell me, among other things, well, what questions or concerns do you have now? What are your objectives? What are your expectations? And then when I have a conversation with them initially, I go over the law, I go over the procedures, and I go over practical problems. In my business, practical problems are, can you recover your attorney's fees? Why people make decisions, that sort of thing. It's similar, in my opinion, with your activities in trying to identify the value that you are going to provide to a client by learning what the buyer wants and needs. And perhaps, and I have to admit, this questionnaire didn't ask it, but you might want to be saying, what does the buyer expect from you? In other words, what services do they expect you to perform? Now, Section B, property preferences and concerns. Many of you remember the old questionnaires about house in this subdivision, or this many bedrooms and bath, this much square footage, things of that nature. Those are what we've got here. School districts being what the significance and importance of those. Then we've got some questions. List all of your priorities, exterior and interior. Why? How many of you have ever had a problem where somebody says, well, I wanted to put a pool in and I couldn't do it, or I wanted to do this or add this, or I wanted to use the property in some way? Well, without something in writing, it's just your word against their word. This says, 7 says, list any future needs or uses for the property, exterior and exterior. Priorities outside, obviously I want a covered awning or an outdoor kitchen or whatever. 8, list any other concerns or issues. All right, then the question here about expertise and past experience, this is in part designed to learn what this buyer is bringing to the transaction. It's also a risk management tool. There is protection if, for example, you've got somebody, let's say under question 1, who's in construction. Well, that means they can perhaps read a set of permits better than you can. First-time buyer versus what other experience you have. Problems or concerns with prior transactions. Inevitably, in a deposition, a buyer will be asked, was this the first home you made an offer on? If not, did you make prior offers? And if so, did you have any problems or concerns with those transactions? We want to know what these people are bringing to the table so we can better represent them. add value, as I've said. Claims history or lawsuits with other properties, if they've got a history of water intrusion issues, then they're going to be more sensitive to that. If they've got allergy issues or sensitivities, ADA issues, and then a catch-all, any other buyer concerns or issues. Now, please take a look at the note. If the information contained in this assessment changes at any time for any reason, you must notify your agent promptly in writing. If you notify your agent in writing, they're incorporated into this assessment. This, once again, is designed to address the moving target. So there's an obligation to update it. Please remember what the our rep agreement requires. This information is provided when you start working with them, and this information is updated when you identify a property, and this is updated after your review of disclosures and information about that property. Now, page 3 is the update and assessment of an identified property. As you can see, it says, now that you have identified the property you want to acquire, make sure that you review all of the information in the buyer needs and wants assessment that you previously completed to confirm that the property meets your preferences, and or to the extent that the property does not do so, that you are still satisfied with your decision to acquire this property. In the event that you do not acquire this property and intend to make an offer on another property, agent encourages you to redo this buyer update and assessment of identified property for that property. Now, this is, so the first 2 pages are generic, they're background. This is property specific. This distinction is not well spelled out in the BMI. The BMI, just says you can talk about things in general, or you can talk about property specific without any other guidance or direction, which is why people read it and they get overwhelmed by it and don't fill anything in. Now, first question, any changes in the information specified in the needs and wants assessment, requiring them to go back to pages 1 and 2 and tell us, all right, anything that's changed. Now, any issues or concerns from your review of the seller's disclosure packet and or any documents, information that you have obtained from any source at any time. So we're not just limiting it to the disclosure packet that's uploaded, but it's whatever else you may have acquired from any source. Now, any issues or concerns from your review of the property, any issues or concerns from your review of the neighborhood. By the way, ladies and gentlemen, if people aren't answering this, if questions are getting left blank, please just send it back and say, it would be helpful to have you fill out this form completely so that I can better understand what I need to do to assist you in acquiring property. Remember also, if they don't do what? Promptly provide this information, you have the ability under the rep agreement to terminate, to cancel. All right, now 5, any issues or concerns from part 1 that are applicable or not applicable to this property. That's number 5. Now, 6 and 7, what are your desired present and or future uses, a defined term of this property? What are your desired repairs, modifications, additions, changes, defined term to this property? This is to prevent what we've already talked about, which is, I wanted horses. I can't have horses. I wanted to add on. I can't add on. I wanted to go up, another story. I can't do that now. That sort of thing. Now, any other issues or concerns with acquiring this property is 8, a broad catch-all. Once again, please pay attention to the note. Same advice and warning. If you've got changes for any reason at any time, then notify your agent promptly in writing. Then, buyer understands, acknowledges, and agrees that agent cannot guarantee that any property will meet any or all of buyer's preferences. Once again, it is their responsibility to determine to what extent the property meets those preferences. Buyer is also responsible for contacting appropriate professionals and governmental entities regarding the viability of the intended uses and or changes. That's where these defined terms relate back to questions 6 and 7. So if there's any use that is going to change, or any change or modification, they're responsible for contacting the professionals and entities. Now, does that mean you can't assist them in any way? Of course not. The problem is just make sure that you don't become the source of the information and limit yourself to being a resource. Who signs this document? Buyer only. Why? Because it is the buyer's needs and wants assessment. Broker doesn't need to sign this. This is not a compensation agreement. The BRBC says you can use this or any other set of documents in writing to provide for that. But we do need to get dates and signatures. Now, this document, this third page, there is another form called the BNWU. BNWU is the acronym. It is the Buyer Update and Assessment of Identified Property. It is the exact same form that we have been looking for, but when the buyer finds another property, what we do is we then have them fill out page 3. Again, it's no longer called the BNWA page 3. It is the BNWU. There is nothing different, however, about the form. So what we've tried to do is create a document that stands alone, apart from the first 2 pages of the needs and wants assessment, and then is applied with each property that the buyer identifies. All right, now, I think I have pointed out already the primary differentiating points between this BRBC and the car rep agreement. The paragraph 7E of the current car form reads buyer material issues. Buyer shall notify broker in writing, paren car form BMI, of any material issue to buyer, such as but not limited to buyer's requests for information on or concerns regarding any particular subject of interest or importance to the buyer. And then 7F says, that's the indemnity. Buyer agrees to indemnify, defend, and hold broker harmless from all claims, disputes, litigation, judgments, attorney's fees, and costs from any incorrect information supplied by buyer or from any material issue that buyer fails to disclose in writing to the broker. Why am I going over this? Because that right now is the biggest issue. If everybody right now is talking with their client and learning what it is that the client wants, how and where and when they document that information is what's critical. The car form locks you into using the BMI, whereas we've provided for the flexibility that you don't have to use it. In addition, if you look at pages 1 and 2 of our needs and wants assessment, I think you'll find that that's a lot more helpful than the language here that says buyer shall notify broker in writing of any material issue such as buyer's request for information on or concerns regarding any particular subject of interest or importance to the buyer. Talk about a vague, open-ended document. The other thing is, doesn't address neither the rep agreement or the BMI address confidentiality. They don't address how and when that will be used. Now, the car document has a mediation clause. I've already explained to you why we eliminated that. We didn't want that in there. And again, most important thing at this point is the car form, the BMI isn't even bundled when you print it out. So right now, my concern is that that form is going to lock you into, a problem. All right, now, Matching your services to a buyer's concerns, needs, wants, and motivation is probably the critical issue that buyers agents face right now in trying to get the buyer to sign the agreement. Providing value is the word I've repeated all day. It's just a very worn out word right now. But that's what it's going to take in order to get people to sign this. Historically, these agreements have only been used by a small number of people who previously had been burned on getting paid. And as a result, that's going to expand, because if in fact, I stress, if in fact, the decisions that have been rendered here recently remain in place, then the traditional and historic method and offer of compensation is going to change. And we're going to have a discussion about the negotiability of all of that. Now, I'd like to spend just a few minutes, because right now the entire industry seems to be focused on the buy side. You know, getting this particular contract out, getting people to understand it, how to use it, why it's important, all of which is certainly significant and important. But what we don't seem to be having as much of a discussion about at this moment in time, perhaps some have, is what are the implications of the Missouri decision with regard to listing agents? What impact is that decision potentially going to have on the number of agents that are out there? What impact is that decision going to have on the number of dual agency transactions that exist? Because I'm certainly anticipating that many listing agents are going to be saying to buyers, or buyers are going to be approaching listing agents and saying, hey, work with me and you will be better off, or the buyer will perceive that that is in fact what is important. But let's just say hypothetically, what obligation does a current listing agent have to discuss the Missouri decision and the negotiation regarding compensation? I believe that they do at this moment in time. While the case is on appeal, Christ, I may not even be talking to you by the time the appeals are done. I mean, to me, this is a case that conceivably could get up to the U.S. Supreme Court for a number of reasons, but that isn't going to happen quickly. And so, can you simply ignore the discussion, the decision at this point in time? The answer is unfortunately no. We have to, as a fiduciary, discuss with both buyers and with sellers the impact of that decision. Now, we all know that the offer of compensation that NAR requires at this point can be zero. And I want you to think about, what obligation does a listing agent have to a seller if at the time that they negotiate their compensation, they say, I will charge you 5%. If I act as a dual agent, I will charge you 4%. And there's got to be a discussion about, what are you going to offer any compensation or not to a buyer? We all know that now NAR rules allow for zero compensation to be offered to a buyer's agent. There's certainly got to be a discussion, one, about what impact that may or may not have on the amount of interest that the property is showing, even though that it's totally unethical to not show a property because of that. But the reality is that that may happen still. More importantly, if the offer of compensation is zero, what impact is that going to have on buyers' ability to buy? Because currently, as you all know, we have no ability to finance the payment of that compensation that needs to get paid to a buyer's broker, at least currently. So there's a consequence here is how is it going to impact the number of buyers that may be interested in the property and their ability to buy? Maybe a bigger issue at different price points. Let's go with the following: 5% commission, and the buyer comes in and says, I'm going to take care of my own agent's commission. And what obligation does the listing agent, the seller's agent, have to have had a discussion with the seller about, well, if that is going to be if that is going to be a zero offer of compensation, am I, as a listing agent, still entitled to get my 5% if the buyer's agent comes in and pays their own broker? I think I would be worried about that if I were representing the listing agent. If the whole premise or part of the premise of these lawsuits is that compensation has been inflated and sellers have been paying more than they should have because of the offer of compensation, why wouldn't that apply then to a 5% when there actually is a buyer's agent who is getting paid by their own broker? So let's not lose sight that there are issues that need to be discussed and addressed. The pros and cons of them need to be discussed and addressed with the seller as much as there is with the buyer. Here's something else. List prices aren't a function of how much commission somebody is being paid or not paid. List prices are a function of what the property is worth in the market. What is impacted by the amount of the commission is the net to the seller. And that is what we ought to be focused on in our discussions with the seller in terms of discussing compensation as much as anything else. Believe it or not, that is what I have to tell you at this moment in time. I really wish that questions could be handled a little bit differently, but if people do have questions, let's see what we can try to handle. I will tell you this. The last time we talked about this, I told everybody if they had some questions to just get a hold of me. I did get questions, and I spoke to every one of the people who sent me an email. So as long as I don't have a conflict, I'm more than willing to do that again. Paul, you're scanning those to see where we are or not.
I have been, Dave, and there have been many questions, but the one most popular that has come through in all different iterations, and I think you touched on it, but you may want to address it, is can you use the PRDS form, either of the new forms, if you're going to write a RPA contract? Or vice versa, can you use the CAR buyer representation agreement, but then still write on the REPC? And I believe you said these forms are all interchangeable and can be used on one platform or another.
Okay, great question. First of all, I mentioned briefly that if you want to use the BRBC, whether it's a PRDS one or a CAR one, with the PRDS purchase contract, you would have to write an addendum to address the issue of buyer's compensation. Remember that you can't, under the CAR contract, write that unless you already have a signed buyer rep agreement. So the thing is that, again, use an addendum because, as I said, the committee has been discussing whether it is more advantageous to a buyer's broker in terms of trying to have an open and frank discussion about compensation, but also not end up in a commission dectomy, more or less, to approach the seller with a compensation request ahead of time. If the seller responds and says, I'll only do it under the following circumstances, at least you know what that is, and you obviously have a fiduciary duty to communicate that to your client and discuss the pros and cons of it. In no circumstance can you put your interests obviously above that of your client, the buyer. However, so the needs and wants form can be used it can be used on its own without a buyer rep agreement. It can be used in conjunction with either one, provided if you're going to use the car buyer rep agreement, you indicate under other terms and conditions that instead of using the BMI, I'm using the needs and wants assessment. Okay, that's the key to that. Can you use a car buyer rep agreement with a PRDS contract or vice versa? You can, with the exception of, as I said, the car form has the paragraph. I think it's excuse me, one sec. Just went to get my form book out so I can give you the exact, paragraph. It is 3G3, where you check the box off, and it says the seller agrees to pay the obligation of buyer to compensate buyer's broker under a separate agreement, and then they have a form attached, the SPBB. So what we don't currently have any language in the PRDS contract, to do that. But if you want to do it, as I said, use an addendum and just identify what request for compensation you are requesting and under what circumstances is the way to do it. We as a committee will be discussing whether we are going to include or not include a similar clause in paragraph similar to 3G. I can tell you this, if Vicki Nadorf were making the vote, the answer would be no. She feels extremely strongly about the fact that if you tie those together, you are going to create more issues to negotiate that are more likely to result in a reduction in your commission. That's her position. We really need to talk about it with the committee. What you can use again is a compensation agreement between the buyer's broker and the seller. Negotiate that prior to the offer being submitted. That is what she thinks is the most advantageous thing to do. And who are any of us to dispute what Ms. Nadorf thinks is appropriate. I certainly do not want to put my head in that mouth as I did yesterday afternoon when we had a lovely chat about some of these issues. You guys, everybody that's on here knows our friendship and our respect for each other. But she feels very strongly about that. We haven't really talked about it at the committee. So that's one of the next things we got to approach.
Thank you, Dave. We put your email address in the chat for everyone, and I think there's 4 or 5 more questions. You've covered several of them with your recent comments. We have, given the complexity of the buyer needs and wants forms, is there a reason that the agent cannot ask the questions, write down the answers, and then ask the buyer to review and sign? Yes,
because you are the scribe then, even though the buyer is reviewing and signing it. Again, this isn't, I think this is an interesting question in part because of the following. Our industry has had a discussion about how detailed the SFC is versus the SPQ. It's funny, depending upon which side of the question you come from, and I know Vicky does, John Till does, and other agents view it as it is helping you. It's protecting you because it is putting the burden on the seller to fill it out. Why limit what it is that the buyer may or may not say? Make them go through it. The key to this, in my opinion, and according to NAR, their course material is convincing the buyer that this information will allow you to better assist them. Here's some of the quotes out of the NAR material, ladies and gentlemen. Define your value by learning what is important to the buyer. That's the approach they're taking. Match your services to the buyer's motivations, concerns, and needs. You provide services, information, knowledge, guidance, and referrals in exchange for compensation. Learn not only what the buyer needs and wants and needs are, but also learn what the buyer wants from you. What are the service expectations? And those are direct quotes out of that course material. And so I look at that and I say, well, interestingly enough, I had lunch with a client last week, and he had written out a list, and he says it was very long, of how agents provide value to their client as a buyer's agent. And negotiating is one thing, obviously. Identifying property, perhaps to a lesser degree, given how much information is on the internet. But if you go back to the NAR material, the NAR material discusses, these sorts of issues in terms of what buyers want most from their agents. 51% of some survey from 2021 said help find the right home to purchase. 13% said help buyer negotiate the terms of sale. 11 said help with the price negotiations. 8 says help with the paperwork. 6% determine what comparable homes are selling for, and then other. Well, what I'm going to tell you is going to be, this is nothing new. The focus has already been there. But I mean, analyzing the condition of the property based upon the disclosures, based upon the reports, and then making recommendations or underscoring recommendations that are already made in these reports to a client and saying, look, this is of a potential concern or not. Here's what I think you need to do in order to evaluate that. I think we need to be focused on locating property to a lesser degree, but does that property meet their needs and wants? Does it match their concerns? And why or why not? I mean, reading what they give you and saying, okay, are you sure this is the right one? And then, documenting that in a polite way, I think, is how you're going to provide value to your client. Explaining how complicated this process is, the stages of an escrow, what has to happen, the coordination that needs to take place, all of that, most people don't know about. And whether you want to do it, as I said, on a hybrid model, which we see it to some degree, that's your choice. But I don't recommend reading them. That's the same thing as reading the TDS, in my opinion, and then filling it out and having them date and sign it. I think you're potentially exposing yourself where you shouldn't, in my opinion.
Thank you, Dave. Just to reiterate, someone's asking again, if you use the BRBC, the PRDS version, but you don't have or don't use the buyer needs and wants or a signed agreement about needs and wants, is there a problem? Are there any issues?
No, you remember the agreement we prepared says it's just got to be in writing, but it can be any form of writings. Okay. And think about what most people do now is they discuss things verbally, maybe they confirm them in some level of writing. Fine, if that's what you want to continue to do, I think you are leaving potentially information on the table that might impact somebody's decision-making process, number one. To the extent that you are not relying on the same set of questions, you may get, a fair housing issue. Number three, it's just more detailed. Remember, a question prompts a response, or it should. Is there time involved? Absolutely. But it's the same reason why you explain to a seller, take the time filling this document out. Why is this document so important, the TDS or the SSC or the SPQ? Why is this particular document, whatever set of documents you use, so important? Because this is going to allow me to represent you better, more effectively, more efficiently, and help you make a more full and informed decision.
Thanks, Dave. Next question. If the broker must sign the new buyer agreement because it binds the compensation between the client and the broker, with that logic, why isn't there a place for the broker's signature on the listing agreement?
On the listing agreement? You're talking about our listing agreement?
It doesn't specify.
It does. Page 5, listing brokerage, broker DRE number.
Thanks, Dave.
By, listing agent, but you still got to have, the broker identified and the broker DRE number.
The the next question, if a buyer can't afford to pay compensation, their broker's compensation, should that be written into the buyer's info, and how can that be communicated to the seller in an offer?
Well, if the buyer can't pay, then we're going to have a problem about whether the buyer can afford, to purchase this property. This probably is a good example of why you would want to approach the seller ahead of time and explain that and work that out before writing an offer. I guess the other reaction I have to that is that how long has the property been on the market? I think some of the answers to these questions about the negotiation and the flexibility that sellers and buyers have will turn on the motivations. I mean, if a property has been listed without any activity for a number of months, maybe that seller will suddenly be a little bit more motivated, to negotiate on that particular issue. But I think the biggest concern is the first reaction I had is, unfortunately, not offering compensation may eliminate buyers. And if a buyer says, look, I'll pay your price, but pay my guy, my client, my broker some money, there's a deal to be done, traditionally, but the impact is really a question of the net to everybody. So that's my response to that.
Okay. Next question is in the buyer representation and broker compensation agreement, section 9B. What is the fee versus the acquisition fee?
I'm sorry, in paragraph 9B,
B,
and the question, I've got it right here. What is it?
what is the fee versus the acquisition fee?
I'm sorry, just point me to where that word is.
I don't have the form up. I'm
Okay,
sorry,
well,
Dave.
the compensation is what is spelled out in 9A, provided something's filled in for a traditional sale. So acquisition fee and or fee is what the amount of compensation will be, assuming there is a close of escrow or a triggering event under the safety clause occurs within 90 days. It's that fee. If
Okay.
there's some word there that we've doubled up on, if somebody just drops me an email, I'll, as I said, reluctantly stick my head in the lion's mouth and talk to Ms. Nadorf about it. You guys are, I'm smiling because, you know, I can't tell you how much time we've spent, she and I, you know, drafting this thing and redrafting it and trying to, you know, refine it as best we could.
Next question. Someone asked if you could repeat the title of the NAR material you're mentioning, I guess
Yes.
the ABR material.
Yeah, absolutely. So I got this from a broker client of mine who took the course. And as you all know, I'm technologically, you know, bankrupt. So it was sent electronically and Molly printed it out for me. The title is Student Manual, Accredited Buyer's Representative Official Designation Course, ABR. That's Accredited Buyer's Rep. So there is a designation that they offer. As I said, CAR doesn't offer it. I just thought it was, when I started looking into these issues back when I wrote the first of 2 articles about the new CAR rep agreements, I just said, well, does CAR have a course? Because I wanted to see if their material tracked with their course. And when I contacted one of my broker clients, he told me, no, they don't. The only course that's offered is the NAR course. And so I said, well, give me that stuff. I want to read it. So I spent part of a weekend, you know, looking it over and then comparing what was in there to what was in the CAR rep agreement. And then when Vicki and I and the committee started to work on ours, trying to adapt and address issues that they had already represented. And if you remember, one of the articles I wrote was, you know, how can we not have a needs and wants assessment when the only accredited course says that's something you need to figure out when you start working with somebody, if nothing more, to figure out whether you want to waste the time doing so if they can't really afford something. So anyway, that's, what else do we got?
And Dave, I actually looked at the form. That 9B deals with options, the option section. But the next question is,
I'm B. Oh, I'm
Yes.
sorry. I'm sorry. In the event buyer secures an option, a fee of blank and an acquisition fee of, in the event the option is exercised. So there may be 2 different fees based upon just getting into the contract. And the second thing then is when the option is exercised. That's why it would be, when the option is exercised, there's an acquisition fee. That's the explanation. Whereas the fee previously might just be, you're going to pay me, you know, X, not tied to the acquisition price or anything.
Okay. We have another question. Could you please tell us how we can best explain to the buyer that the buyer broker representation and compensation agreement is also beneficial to the buyers and not only to the buyer's agents? So maybe they see value and sign it.
You know, I'm going to start by saying the following. I probably need as much as anybody to sit in and hear how experienced brokers and agents present this to a client. What I'd like you all to realize is that Vicki and I have never sold real estate. What we have done in our careers is try to manage risk associated with real estate transactions from a legal perspective. And so I don't know that I'm the most qualified person to tell, you know, how to present a form. I'm learning, I'm working like everybody is to try to understand how to do that. So please maybe ask, you know, some other people who do this, you know, rather than me. I've never sat and, hey, Paul, I want to represent you, you know, you know, sit down here and go over this form. I mean, so remember that our approach is from a risk management approach. We try to take into the marketplace realities, but I don't pretend to represent that I have all of the answers relative to, you know, this. What I would try to do, and what everybody seems to be stressing, is what I've said, which is, where is the value to the buyer in entering into this relationship and providing this information? And to me, it is the more information you provide me, the better I will be able to assist you in not only identifying property to the extent that you need any help, but also evaluating that property and allowing you to make an informed decision about whether to purchase a particular property or not. To me, that is where the value is. It's the same reason, ladies and gentlemen, that I get asked occasionally, primarily from people from the East Coast, well, can you represent me, you know, in this transaction? And I tell them, no, I'm not licensed to do that. Could I do it? Sure. Am I set up from a tracking and a monitoring standpoint to do it? No. I think we're also losing sight of, you know, the market, maybe at some point, will revert to what it was at one time, which was you got into contracts, you ratified, there was a period of time to investigate, there was a period of time to negotiate, you know, in terms of repairs or things of that nature. There was definitely a need to monitor and track the transaction. And as you guys have the programs to do that, I would literally need to create the timeline, you know, every time, you know, to do that. So I think that long way of getting to where I'm saying is explaining to them that the more I know about you and the problem, you know, the issues, the concerns, what you're looking for, the better I can help you accomplish the goal that you want, which is to buy a house that meets certain needs and wants and other criteria. That is, I think, what you have to sell, you know, and convince the buyer agent. Now, again, if there are buyer's agents out there that have dealt with this, please, if you want to send me an email with giving me something about what you do or try to say, I'd love it, because I'll give you full credit the next time I talk.
And I guess there's one last question in the chat, Dave, which is, do you see the buyer broker agreement becoming mandatory, like the listing agreement is mandatory to work with sellers?
All right. Some of you may have already heard this. I did have a lot of fun, and I'm glad I can end on this. I'm going to read you off some dates. February 22nd, 1984. January 1, 1987. January 1, 1988. April 14th, 1998. January of 2006. September of 2010. And November 21st of 2016. Now, the first date is when the Easton versus Strasburger decision came down. The second date, January 1 of 87, is when the TDS law went into effect. January 1 of 88 was the agency laws went into effect. And, you know, the offer of compensation remained, but not the offer of sub-agency. April 14th, 1998, Field versus Century 21 Clouden, which is the appellate decision that now provides the basis for KC 4107, jury instruction on common law fiduciary duties. January of 2006, non-confidentiality of offers. To this day, I remember where I was sitting when I got a phone call from Carol Burnett and another phone call from Jeff Barnett. And I can't remember the third person on that day when NAR modified their rules about confidentiality of offers. All of us were dumbfounded. And it was like, oh my God, what the hell's going on? September of 2010, the policy regarding IDX feeds came into play. November 21st of 2016, the infamous Hurricane of Caldwell Banker of Southern California why am I having fun with this? Because these were all watershed moments. And every one of us thought, oh my God, real estate as we know it is going to change. The world is just not the same. Well, we got through every single one of these. I'm going to tell you something else, ladies and gentlemen. Hariki has been the law since November of 2016. I have had it cited to me less than 5 times. Interesting, right? Because everybody said, oh my God, that's totally contrary to how we do business as an industry. I actually cited it to a lawyer recently because that lawyer had written me that said, believe it or not, well, there were 2 individual agents. Therefore, this is not a dual agency. Never mind the fact that they were working for the same broker. That lawyer obviously had not took the industry, philosophy. So what I'm trying to tell you is, we are at a watershed moment. Do any of us know where this is headed? No. If NAR's got the ability to fund the appeal and battle this out, they may be able to preserve what we have known as the offer of compensation for, I think it's like 75 years, maybe 100. I don't know the answer to that, but I think we do need to realize right now that the writing may be on the wall. And I think we need to adapt our practices, as we all do when something happens. And if nothing else, recognize that by getting this agreement, you are protecting yourself, but you're also enabling you to better represent a client to the extent that you get the information that you need to do so. And we'll see where it's headed. I don't know whether 3 years from now, 4 years from now, we'll be looking back at this going, what the hell was Hammerslaw talking about? Why was everybody just all worked up about this stuff? I did express to you earlier, this could reach the Supreme Court. I'm not an appellate lawyer. I'm not a court watcher. I'm just a humble hod carrier, trust me. But NAR's got enough political clout. They got enough strength that if anybody can get something to the appellate, to the Supreme Court about a real estate issue, if they're backing it, they probably ought to be able to do so. So I hope that answers your question, but I do think we can't ignore it. I do think we have a fiduciary duty to discuss it, to the extent that NAR's rules now say 0 offer of compensation, is okay. We're going to start seeing it. I mean, years ago when the market was hot, I remember in the early 2000s, I got a question at a speech I was giving. Well, the listing agent is only offering $500, in compensation. Is that okay? And I said, wow, that's interesting. I said, probably is. And then the response I got from the individual was, well, I won't show that house to my client, which then alert, I said, whoa, you got fiduciary duty issues. NAR's already addressed that in their rules, but are those potential things that may happen? Of course. Question is anybody going to get caught? Is the real issue. And the answer is probably. Anybody else? And if you don't feel comfortable and you just want to drop me an email, just make sure you leave me your phone number, because those people that I will call you in my commute. I got a 2-hour commute each way. Okay, so.
Thank you, Dave. I think we have exhausted the questions in chat. And once again, thank you for a masterful presentation. And for those who need Dave's information, once again, his email is in the chat. And I can attest to the fact that Dave calls early in the morning or on his commute home. So please don't cut into my quality time with Dave, but if it's important, please feel free to call.
Yeah, absolutely. The other thing is, please pull out a BMI, take a look at it, and compare it to the needs and wants assessment. I just think you will find that they're not even close. And this is a joke. Please accept it as it's intended. I have worked very hard with Paul to negotiate on behalf of Ms. Nadorf and myself, residuals for everybody that purchases or uses that damn needs and wants assessment. This is a huge joke, everybody. Okay, a huge joke. We're having fun with what we do, but I will tell you this. I believe that you will see something similar come out of CAR in some period of time. Okay, how quickly they want to acknowledge this, but I just think that the two forms are not comparable. And CAR comes out with a lot of great forms, people. Please do not think that this is, only PRDS, only Silvar. We're a community. We all work and talk and we communicate and use what people have started with. I just think that when they look at the BMI compared to the needs and wants assessment, and they compare it to what NAR's material even says, I'm predicting that we'll see something of a similar nature on an industry level, which is why I worked hard for my residuals.
We'll talk about that.
Yeah, right. Thank you, boss.
And once again, Dave, thank you for everything.
Thanks everybody for hanging in there.
Vicky and the members of the committee, and I think Mark was on the call. Thank you, Mark, and other members of the Forums Committee. And with that, I will say, first of all, Dave has also agreed to do future webinars on these forums and on these issues as they develop, and so we appreciate that.
Yeah, and if Paul, as I said, I mean, we can have what, 75 at Silvar?
Fewer than that, if we have the fire marshals nearby.
Well, the point being, if there's some people that couldn't make it and want to attend, I'll be glad to do another one, either virtually or in person.
And remember, these are never recorded. People are still asking, these are never recorded.
Well, for those of you who are still listening, I get my articles cited to me in briefs. Well, Mr. Hammerslaw shouldn't be taking that position. This is what he said in an article. And I said, well, you need to read the article a little bit more closely. And on those occasions when I do act as an expert witness, you better believe that the articles I write are definitely fair game for cross-examination, which is why, as I've told you guys for years, you're not going to see a lot of absolute, thou shalt do this. This is the only way to do something, in spite of Ms. Nadorf's nudgings. Dave, you need to tell him to do it this way. Yeah, Vicky, you go ahead and deal with cross-examination.
Exactly.
Anyway, thanks very much, everybody.
And on that note, yeah, thank you, Dave. I wish you and everyone in the audience a happy Thanksgiving.
Great. Thanks, Paul.
Take care.
Yep.